Um, Looking around the room, I've done a lot of these things, and some people in the room may have seen some of these slides already, so apologize for that. But I swear most of these slides are new, so don't worry. So the topic for today that I put together is emerging legal topics in music. Most of the time when I do these things, it's sort of contract basics, deal points, all that kind of stuff. Happy to talk about all that sometime later today, over beers, whatever, I'm around for the day. But for today, I thought I'd do something a little bit different and just talk about more emerging legal topics in music. At least what I think are kind of more newish emerging topics. But before I get into that, I normally always still do the copyright basics and just do that really, really quickly. You look familiar. I've seen you. Yeah, you know some of the answers to the questions too, I bet. So if it's cool with you, I might just go through some copyright basics, because I feel like it's hard to talk about anything in the music industry from a legal perspective without the foundational copyright stuff. And it's only one slide. Is that cool with people? Copyright basics, yeah? Probably stuff you've heard before. So yeah, I'm going to talk about copyright basics, things to ask a lawyer. I'll get there when I get to that slide. But oftentimes I come to these things as well. No one books one-on-one meetings with me, never. And I know that's okay though. But people always come up to me after and they're like, "Dude, I wanted to talk to a lawyer, but I had no idea what to even ask, so I didn't even want to book a one-on-one meeting." And so I thought to myself, okay, well, I'll put together a slide called Things to Ask a Lawyer. So it might trigger a question or something. You might want to ask that question now, or you can ask it maybe after the session. Inclusivity in music law, something I've been thinking about a little bit. I'm going to touch a little bit on inclusion riders, equality in music, why that's important. I think it's a really important topic these days for obvious reasons. Music infringement trivia, I thought that might be kind of cool to talk about just a little bit if we have time. And then we probably most certainly will not have time because I only have 35 minutes. But streaming in the digital dollar, I thought it might be cool to break down how a digital dollar breaks down in your pocket, basically, with when you include performance royalties, mechanicals, all that kind of stuff. May not get there, but we can talk about that after if you want. Whoa, that's not right. Okay, missing a whole bunch of slides here. I'll just briefly touch on copyright anyway, without a slide. So I think the only thing I really need to mention about copyright that people need to fully understand are the two different copyrights. If I'm holding a piece of recorded music, I'm holding two distinct copyrights. I always use the example for whatever reason. If I'm holding the record in my hand, Stevie Wonder's Songs in the Key of Life, I'm holding two distinct copyrights in my hand. I'm holding the copyright in the master recording itself, and I'm holding a copyright in the musical composition, the musical work. They're two completely different business assets within the music industry, and although they're often lumped together, they are completely different business assets, and I couldn't emphasize that more. Depending on what business asset you're dealing with, whether it's on the master side or the musical work side, will trigger certain revenue streams. Depending on your role in the music industry, whether you're an artist, songwriter, or maybe producer, and you go into the studio quite a bit, might depend on what rights you actually own. Maybe you're a songwriter and you own some musical works, but you don't own any masters, and vice versa. You could own some masters, but no musical works, depending on your role in the music industry, and also depending on some of the agreements that you may have signed within the music industry. I think that's really all I want to note about copyright. I had a few different bullets up there. I mean, I talked a little bit about joint works of joint authorship. That pops up a lot at conferences, and I talked to publishers a lot about securing co-rights for their clients and all that kind of stuff. You know, if you are ever writing with another artist, you want to make sure you clarify that it's a work of joint authorship. And oftentimes the best way to do that is to get it in writing. One of the more famous, I guess, Canadian cases around works of joint authorship was a Sarah McLachlan case way back when. And she worked with a producer, and a producer actually claimed that the producer co-owned a whole bunch of the tracks off of a particular record, and it went to trial. Most of these things don't go to trial in Canada, but that case actually did. And the courts in Canada, for the first time, I think, in Canadian law, commented on the definition of a work of joint authorship and what's required. And really what's required is intention to make the works inseparable parts. And if you don't have the intention from the outset, then it's likely not a work of joint authorship. So you have to keep in mind that if you are going into a studio or sitting down with someone and there's the intention to make one inseparable work, then it's likely going to be a work of joint authorship. And so that's really important, I think, generally speaking, in the music context. I don't know how 4 of my slides just totally got deleted, but that happened. Another slide I had up there was just sort of a slide kind of completely separating the 2 different copyrights. I had one bubble, and in the bubble was a sound recording copyright, and the other bubble was the musical work copyright. And with respect to the musical work copyright, typically what happens is if you are a band and you go into a studio, the first owner of a record is under the Copyright Act called a maker. And the maker is kind of this weird, mysterious term used under the Copyright Act, but really what it means is the individual or company or people that have made the arrangements for the master to be recorded. And so if you're a 4-piece band and you go into the studio or you do it yourself, that band you'll be your own maker. However, oftentimes producers are considered to be makers in their own right, or record labels could be a maker as well if they make the arrangements for you to record your master. And so typically what happens with that copyright is you have a maker, that's the first owner of the master, and typically what happens is you might sign a record deal where all or a portion of that copyright goes to the record label. And so it's sort of a very simple kind of overview of how a record deal works, but really that's how it works, is you have a maker, could be a producer, could be a label from the beginning, or it could be a band. You've got your master recording, and then that master recording is then transferred all or partially to a record label. More indie deals these days are sort of license deals, sort of net 50-50 deals, and so oftentimes copyright's actually not assigned at all to the record label. It's just a license that's being assigned. And on the other hand, this really cool slide that I'm talking about that I deleted, on the other hand, there's a bubble with the musical work. The first owner of the musical work under the Copyright Act is the author. And then just like the record label kind of example, typically what happens is once you've got the copyright in the musical work, all or a portion of that copyright gets assigned to a publisher who's then in the business of exploiting your musical works. And so you're kind of either in the business of exploiting musical works in the music industry, or you're in the business of exploiting master recordings, or you could be in the business of exploiting both, making and exploiting both. And I think that's really the big takeaway with respect to copyright. And leading up to that slide there, I mean, obvious example there that everyone's familiar with, All Along the Watchtower, written by Bob Dylan. When Bob Dylan wrote that song, recorded it, he would have received publishing revenue as the owner of the musical work, or as publisher, but just to keep it simple, we'll just say Bob Dylan. And he would have also been the owner of the master recording after recording All Along the Watchtower on their record. However, Jimi Hendrix obviously recorded a pretty badass cover version of that song. When All Along the Watchtower, Jimi Hendrix's version is played on the radio, Jimi Hendrix estate doesn't get any of the publishing. The publishing still goes to Bob Dylan and Bob Dylan's estate. But Jimi Hendrix, as the owner of the master recording copyright, would get royalties, or his estate would get royalties from the sale of that copyright. And similarly, the bottom example, Wrecking Ball, Mozilla was one of multiple co-writers on that song. When that song plays on the radio, Mozilla will still get a little paycheck to this day. Miley Cyrus won't see that. Miley Cyrus, I don't believe, was a co-writer of that song. However, Miley Cyrus, as a performer, would receive royalties through her record deal, through sales, digital streams, whatever, of Wrecking Ball, Miley Cyrus's version. Does that make sense? Without slides, it's throwing me off a bit, but hopefully that makes sense. Okay. So I really do think that that's really the key kind of thing to know from a copyright perspective, is that in the business, there are 2 copyrights. They're completely separate. They work in completely different ways. And whether you're an artist or a publisher or a record label, you really have to, well, particularly if you're an artist, you have to figure out how to control your copyrights and make sure if you're assigning all or a portion of these copyrights that you're doing so and signing a good deal, and whatever that means. That's sort of what I do every now and again, is assist people in trying to figure out what a good deal really means. I'm happy to chat about that later today, if you have questions about publishing deals or record deals or whatever. Getting the ball rolling. So this is the slide I was talking about. I never get the one-on-ones, but maybe with the creation of these slides, people won't be so shy to kind of book a meeting with a lawyer. But I won't answer all of these, but I'll go through them really, really quickly. These are some things that I think whether you're an artist or a publisher or label or whatever, you should maybe be thinking about. Should I have an entertainment lawyer on my team? Why? What do they do? Some people don't know what an entertainment lawyer actually does or a music lawyer does. And really it's, our job is to either consult people generally on business structures, corporate structures, that kind of stuff, or actually review and draft contracts. That's what we do. And it's pretty vital, I think. I mean, if you're presented with a publishing agreement from a publisher, if you're an artist and you're presented with a publishing agreement, I've seen some that are just a few pages. I've seen some that are 30 and 40 pages. And the smallest clause in there can have dramatic effects on your career, sometimes for a year or two, but sometimes for 5, 6, 7, 8, 9, 10 years. And to get locked down in a very, very long-term deal can be very deadly for an artist who wants maybe out of a publishing deal, for example. What business structure should I utilize? A different business structure within the industry, just like different business structures in any kind of business. Sole proprietorship, partnership, or an incorporated company are normally the 3 different kinds of structures that you utilize in the business, in the music industry. And that's no different, whether you're an artist or a label or whether you run a restaurant or something like that. There are maybe tax reasons why you'd want to incorporate, liability reasons why you might want to incorporate, or you might be fine to operate as a partnership. And if you do operate as a partnership, for example, if a band operates as a partnership, you might want to think about doing a band partnership agreement. And there are a lot of good reasons to do that that I won't get into here, but something to think about. The next question, I guess, my band and I have been together for about a year. Should we enter into a band agreement? And if so, what things should we cover in the agreement? Again, that could be a discussion in and of itself. Some of these band agreements can get long. You can keep them short and sweet, though, but you got to make sure you include the right things. Should I trademark my band name or stage name? What rights do I have if I get stiffed by a venue owner, an operator, don't get paid? Thinking about signing a management deal, what are some major deal points in a management contract? I probably see more management contracts and do more management deals than anything else. So it's really, really important that if you sign a management deal that you look through it very, very carefully. Does it have a key man clause in it? Do you need a key man clause in it? How long is the agreement? When can it be terminated? Is there a sunset provision? So after the agreement has expired, is the manager going to be continuing to collect commissions? What is the commission rate? Is that reasonable, yes or no? All these are just sort of really high-level terms within a contract, a management deal you want to think about. Haven't spent much time thinking about my taxes. What do I need to know? Really important to know about your taxes, obviously. Co-write with other artists. Should I sign a co-write agreement before writing sessions? What's music publishing and how do I make money from music publishing? Probably the most complicated part of the music industry, in my view, is music publishing. And so really, really important to get a grasp of that. As an artist, for sure, obviously as a publisher, you'd be well versed in it. But as an artist, you really need to understand how music publishing works and how you can make money from exploitation of your songs. What's SOCAN, CMRRA? I guess the same thing now because SOCAN bought CMRRA, I believe. Actor Rax, Resound, MROC. When I first started getting into this, my head was spinning as to what all of these organizations and societies do. It's really important to understand each of them. Hitting the road soon, what do I need to know about performance contracts, insurance, visas, if you're crossing the border? 10 minutes only. Oh man, okay. All right. So I'm just going to jump maybe right to the new stuff that I guess was the more emerging stuff. So I've done a little bit of research in this and unfortunately came across these really, really horrible stats about women in the music industry. 94% of women and this is just the entertainment industry, not limited to music, by the way, but entertainment. 94% of women in the entertainment industry experience assault harassment. Well, only 1 in 4 women come forward. 69% of women touched in a sexual way. Like, these are really, really horrible stats, and they're recent stats. 2017 Billboard Hot 100, 16.8% artists were female, only 11 songwriters, 1.8 were producers. Grammys over 2013 to 2018 period, only 9.3% nominees were women. So the list kind of goes on, and a quote that really stuck with me from another lawyer that presented at a copyright conference was that really the entertainment industry right now is a culture of overt sexism, harassment, and assault. it's a very, very, very overt, harsh statement, but I think if you look at these stats, it's hard to describe it as anything but. And so I kind of started thinking a little bit about, okay, well, what can we do as lawyers to maybe make contracts look a little bit more inclusive, whatever that means. And thought about, this sort of thing that everyone's talking about called inclusion riders. They've been around for a little while, just in different forms, but inclusion riders sort of got really, really popular when Frances McDormand mentioned inclusion riders during her acceptance speech at this year's Oscars. And effectively, it's language within actors, producers, directors, contracts that they can bake in, demanding that their projects make a concerted effort to cast minorities, LGBTQ actors, and women in supporting and background roles. So I think a very, very kind of important kind of thing that we should be looking at to include in contracts. And obviously, this is sort of something very, very relevant in the film and industry, and the film and TV business. Not so much music yet, but film and TV are sort of dealing with this. So an inclusion rider would effectively stipulate that characters in film should represent and reflect the world in which we live. And so the breakdown that I've kind of seen time and time again is 50% gender parity, 40% inclusion for people of color, 5% LGBTQ, and 20% disabled. In my view, if you're drafting contracts, it could look much different. You get really, really creative, I think, as to what this breakdown looks like. But I think the most important thing is that you have conversations about these items and how you can bake them into contracts. Because I think it's a really, really important initiative. And I think the more actors and the more musicians and artists that have bargaining power, that are able to actually leverage that bargaining power and get this stuff baked into contracts, the more prevalent these clauses will actually be. Unfortunately, we're at a state right now where if you don't have any bargaining power, it's going to be tricky to include that into a contract. But the more people that are able to do so, the more standard language is going to be out there, the more, again, prevalent these clauses are going to be. As of right now, you can't even really find a draft inclusion rider online. And so I figured for this presentation, I would take a good shot at drafting one. There is one lawyer out there that's drafted these. I know some people are going to take a picture of this, but this is not perfect, and discussion purposes only, not legal advice. Got to throw that out there. So depending on what the project is, companies shall use best/reasonable efforts. Best and reasonable efforts mean something different under the law, to ensure that personnel contributing to the quote-unquote project, whatever that means, whether for profit or otherwise, reflects X% gender parity, X% people of color, etc. And that I call the equality obligation. And so baked into these contracts, whether it's a production company, a festival, whatever, could even be a publisher, they would have equality obligations. And should company breach the equality obligation, artists may terminate the agreement, full stop. And that would really be the point of this, is that if I, an artist, sign up to play at a festival, or if I sign a record deal with a company that is not concerned about this, is not concerned about gender parity, is not concerned about having inclusive events, it gives me an opportunity as an artist to maybe have a way out. That's where things might get a little bit tricky, difficult to know, for example, if that's breached, what are the damages? Really hard to quantify. 5 minutes? Let's see, yeah. It's really, really hard to quantify breach of an inclusion rider, but at the very least, you could bake in a termination right. And I think that's really, really important, flexibility for an artist that wants out of a contract with a company, with a person that is not fulfilling their expectations, we can say. And having that flexibility and knowing that you can walk, I think is really, really important. Most favored nations clauses. And this was sort of another thought, I guess, and I'll just close on this. So we've got inclusion riders, something that I think could be baked into more contracts down the road, not just in conference or performance contracts, but also in publishing contracts, that kind of stuff. But most favored nation clauses could also be something that could touch on equality and exclusivity. So this has largely been applied to the film and TV world. So for example, if I'm an actor, if I'm George Clooney, and I want to, and if I'm sought out by a production company to sign a contract to star in X film, if Ben Affleck is also going to be a star, I want to make sure as Matt Damon that Ben Affleck is not going to be making $100,000 more than me. So what I do is I bake in a most favored nation clause into the contract and ensure that we are on the same page money-wise, that if I sign this contract for $1 million, there's no other lead in this film that's going to be paid more than $1 million. And I started thinking, well, maybe we could start to bake that into performance contracts at festivals and that kind of stuff. So if I'm a headliner and I'm part of a traditionally marginalized group, and I'm worried that, hey, the headliner the following day, I feel like is going to be getting paid a lot more than myself, I can bake in maybe a most favored nation clause into my contract and say, hey, if I'm a headliner on Friday, normally I get stiffed. Fuck that, that's not happening this time around. Whatever the headliner is the next day is going to be no more favorable than what I'm getting paid on Friday. So long story short, I think there are ways to make contracts more inclusive. I think as lawyers, what we do is generally pretty boring, but I think now is a really, really good time to have these conversations. And I think whether it comes to most favored nation clauses or whether it comes to inclusivity riders, they're two very good opportunities to start to have the conversation about making contracts more inclusive and equal. Thanks.